Ladies and gentlemen, thank you very much for the invitation to be here. I'm a biostatistician whose work at the interface of public health and criminal justice has focused on injection drug users, and so bloodborne viruses, drugs-related deaths soon after release from prison, and suicides in prison. So I might, as it were, start with the conclusions that I'd like to draw, which are that epidemiology matters, timelines matter in investigations, the evidence-led matters. My examples will come from Scotland, and the national poet for Scotland said, "Facts are cheels that win a ding." In other words, you can't get around the facts. Consistency of judgment matters, and timeliness matters. The spark for this investigation was when I was driving to Scotland at Easter in 2005, and the Herald newspaper was reporting on the fatal accident inquiry into JCB's suicide in January 2002 at Kilmarnock Prison, Scotland's first private prison. What sparked my attention was the waiting time of 38 months for the fatal accident inquiry to report, and I asked the question, how unusual is it to have a delay time of 38 months? The Scottish courts couldn't tell me, the Scottish Prison Service couldn't tell me. Let me start with a little bit of background on suicides in Scottish prisons. Work by Harris and Barraclough in 1998 suggested that the suicide risk is 10 times greater for those who are opiate dependent, heroin users, than for other members of the public. And so in order to ask whether suicides in prison are an exacerbation due to being in prison or a reflection of opiate dependent risk, you could use a method like this. The suicide rate depends upon age, so you've got a different suicide rate for each age group, and then you multiply that by the number of heroin dependent prisoners that you have, plus the number of others. But because of Barraclough, you inflate the risk for the heroin dependent users by a factor of 10. And that way you would get at an expected number of suicides taking into account heroin dependency. And when you do that, you find that for the period 1994 to 2003, there were an expected suicides of somewhere around 80 to 86 suicides, and the observed number of suicides in Scottish prisons over that 10-year period was 108, so considerably greater. You'll also notice that the superscript R there, which refers to remand prisoners, shows that in the youngest age group, a preponderance of those 40 suicides, 32 of them were young prisoners on remand. This is the remarkable Colonel Clive Fairweather, who is was Scotland's best Chief Inspector of Prisons, and he did a lot of work to try to reduce suicides in prisons. His review on women offenders, A Safer Way, was in the wake of a series of suicides by female prisoners in Scotland. A further report, Punishment First, Verdict Later, was on remand prisoners at the end of the 20th century. And then a series of reports on Kilmarnock Prison, based on his inspections there, the first private prison in Scotland. Scottish Prison Service, during this period, 1994 to 2003, had made a number of interventions to reduce prison suicides. The Act to Care, which essentially means suicide is everybody's business. Mental health nurse assessments at reception. In-cell television, a recommendation by Clive Fairweather, the Chief Inspector of Prisons, initially blocked by the Secretary of State for Scotland. Induction for remand prisoners, and methadone maintenance for those who are opiate dependent. A lot had happened, and yet here we have a suicide in January 2002 in Kilmarnock Prison that did not report for 38 months. The inquest didn't report. So let's look at, first of all, at timelines. What was going on in the background at Kilmarnock Prison? Well, Clive Fairweather had inspected in opened only in 1999. He inspected in 2000, 2001, and 2002 because he did risk-based assessment inspections. And his report in 2002 was issued only 1 month after he had inspected, and he said there have been 5 deaths in custody since March 2001, including, subject to fatal accident inquiry, 3 suicides and 1 drugs-related death. This report was issued 3 months after JCB's death, and a footnote, apparently the recent dismissal of 2 prison custody officers was connected to one of these deaths. And he also notes that at full inspection in 2000, he hadn't been allowed to express the turnover as a percentage of staff because this was regarded as confidential in a private prison. So revealing this is now an inspector behaving badly, and indeed he was let go as Scotland's best ever Chief Inspector of Prisons later in 2002. So we then have a former moderator of the Church of Scotland as the inspector rather than a colonel from the SAS. Here coyly he says some modifications in the high risk assessment were made in the light of experience gained from incidents. What he means is tragedy of prison suicides. And he also says that the inspectorate took a random sample of documentation which included some only of the 17 prisoners on high risk assessment and found the documentation was well maintained, and uniquely, here we have plot it for private prison, the staff numbers increased by 10% when the prisoner numbers increased. In other words, that didn't happen in the public sector. A year later, he said, whoops, the director's rules that any prisoner who had been in high-risk assessment in the past 6 months and is received into prison again will automatically be on high-risk assessment initially. He said that's doubled the number who are on high-risk assessment, but now he's a bit worried about the staffing because it's below what would be expected for comparable public prisons. Unfortunately for the Chief Inspector of Prisons, the BBC was on the case as well. And so there was a real story, undercover investigation going on by journalists. There was a journalist in training to be a prison custody officer. He was in training at the period that the inspector was inspecting, and then he was in situ as a prison custody officer in the subsequent 2 months. And so he finished that spell in January 2005. The BBC transmitted at the beginning of March 2005, 8 days before the fatal accident inquiry report, and in that transmission they showed missed suicide watches, and they interviewed the former Chief Inspector of Prisons, who said that he considered it malfeasance in public service and that they should actually not just be dismissed but should face criminal charges. So I had to learn about fatal accident inquiries. In Scotland, the fatal accident inquiries considering prisoner death in a particular prison will be dealt with in the court in whose jurisdiction that prison is, but different sheriffs, different judges may preside in that court. The Scottish Court's website is supposed to mount written determinations that are particularly important for people to know about. Wasn't happening. The Scottish Prison Service did, however, have a database on prisoner deaths. And so, with the help of the Scottish Prison Service, identifying the 97 deaths to me in Scottish prison custody, I issued freedom of information requests to each of the courts in whose jurisdiction there had been prisoner deaths in the period 1999 to 2003, a 5-year period. What I required was the initials, sex, remand, convicted status, and date of birth of the deceased, the date and place and cause of death, the date the fatal accident inquiry ended, whether it ended with formal findings, which basically just gives the date and cause of death, or a written determination. If there was a written determination, I wanted a copy of the written determination, please, the determination date, and the precautions that might have prevented the death. So that's the important bit, the section of this particular act in Scotland. So, long elapsed time. How unusual was it to wait more than 3 years? Well, only 3 of the 97 fatal accident inquiries had had a delay of at least 3 years. Only 42 of the 97 made written determinations. I was proposing to make a recommendation that a fatal accident inquiry should conclude its inquiries within a year, and the sheriff, the judge, should have at most 90 days to write up the report. And so a reasonable target was that the determination should be in the public domain within 455 days. And that target was exceeded by 13 of the 97 fatal accident inquiries. 3 of them identified precautions that could have prevented death. None of those 3 was on the Scottish Court's website to be drawn to wider attention. And 21 of the 97 fatal accident inquiries continued beyond a year, versus 9 out of the previous 106 fatal accident inquiries, so it looked as though things were getting worse, not better. So, having read through those written determinations and formal findings, I proposed the following scrutiny rules for use by lawyers and sheriffs. First one, a non-self-inflicted death in a remand prisoner. This is an infrequent form of death, occurred in only 5 out of the 38, and therefore was reason to look specifically and write up such cases. Rule 2, young age. Somebody under the age of 21 who dies in the custody of the state, or an exceptional cause of death. Drug toxicity is actually an exceptional cause of death in a prisoner, and self-inflicted death by a means other than hanging, the most usual means being hanging. So epidemiology would tell you these things are unusual. Sheriff, you should write them up. 3, a long elapsed time from the death to the end of the fatal accident inquiry, more than a year. Usually that means there's a much higher likelihood that you are going to have critical findings or recommendations made to Uncle Joe Cobley and all. So those rules, if I applied those 3 rules to my initial set of 97 fatal accident inquiries, I'd have had lawyers and sheriffs scrutinizing 38 of them, somewhere between 30% and 50% of them, had reason to be written up. Applying those rules to the previous 5 years, to the 106 fatal accident inquiries that had been in that period, would have selected 30 for scrutiny. Or another way of saying it, all those 30 should have been written up and on the Scottish Court's website. So non-self-inflicted death in a remand prisoner, epileptic seizure, duodenal hemorrhage, pulmonary embolus and multiple myeloma, pulmonary embolus and DVD after an earlier shotgun wound, and a myocardial infarction in a 50-year-old. We are talking Scotland here. And the long elapsed time, as we said before, only 9 out of the 106. The exceptional causes of death in the period that I was primarily studying, 1999 to 2003, included intracranial hemorrhage. There's not much the prison service can do about that. Myocardial infarction, there sometimes is. It depends how quickly there's a defibrillator and an ambulance. Acute peritonitis due to perforated duodenal ulcer. There were critical findings made about that death. Ischemic heart disease, long alcohol dependency, and dextropropoxyphone overdose at Edinburgh Prison. This dextropropoxyphone was actually banned in the United Kingdom in 2004. Rule 2, if there were the following had only formal findings, no written determination, despite 6 of the deaths being under the age of 21 and 6 of them being exceptional causes of death. Again, dextropropoxyphene, now 2 deaths, dextropropoxyphene at Edinburgh Prison. You know what James Bond says, once is happenstance, twice is coincidence, 3rd time in its enemy action. Exsanguination after a sharp force injury, drugs overdose, aspiration of gastric contents, drugs, and drugs toxicity. These you wouldn't see nowadays because of opiate substitution therapy. So, recommendations. Practice needed to change. Lawyers' families could use the three rules to select fatal accident inquiries for scrutiny and learn from previous practice. Independent oversight was needed because missed suicide watches, which was part of the cause of JCB's death, not the cause of, part of what was of concern in JCB's death, occurred in 4 determinations, but the stringency of judgment differed, and none of them was written up on the Scottish Court's website. So let me briefly show you the waiting times for dissemination in those missed suicide watch fatal accident inquiries. The first one, first death in this period had occurred in April 1999 at Edinburgh Prison, a remand prisoner aged 30 years. Fatal accident inquiry ended in December 1999, written determination in February 2000, all very prompt, no censure whatsoever, and it wasn't even clear from who the sheriff had been. Now we have JCB at Kilmarnock, 30 years, remand prisoner, death in January 2002, fatal accident inquiry ended in March 2003. The judge took 2 years to write up the determination. You know that there is something amiss. Polmont, a 19-year-old convicted prisoner, convicted young offender, death in February 2002, just a month after Polmont. The fatal accident inquiry took 2 years to end, then was written up in about 6 months or so. Kilmarnock again, GM, 41-year-old convicted prisoner, April 2003. The month after JCB's fatal accident inquiry had ended, they knew perfectly well that missed suicide watches were implicated. Same thing a month later. The Scottish Prison Service has the same team of barristers dealing with all of those cases. So the legal teams know perfectly well what's going on. Of course, the family is defended by a different solicitor barrister on every occasion. And then KL, February 2002, his date of death. This is not missed suicide watch, but 2 years for the fatal accident inquiry to end. Well, you know there's something amiss when you see that. So what was amiss here? This man was a former heroin user. He'd been knocked about the head. He had uncontrolled epilepsy. He was on methadone maintenance in prison. He was initially in Barlinnie prison. And the written determination did not specify the dose of his anti-epileptic medication, except that it was wrong. He had a grand mal seizure in Barlinnie prison, and the written determination said the dose was put up. He was then transferred to Kilmarnock prison when the dose actually went down again. The sheriff didn't mention any of these 3 doses. There is actually quite a narrow therapeutic window for anti-epileptic medication. So the difference between 1500 and 1400 could be important. This man's medication went from 1500, i.e. 500 3 times a day, down to 500 once a day, presumably because somebody had overlooked the 3 times a day. Being a prisoner, he didn't complain until he had grand mal seizure, and then he said, well, doc, you reduced my dose. So what did the doctor do? The prison doctor put it up to 600, which is ridiculous. And that's why the judge didn't mention it, I suspect. So I called for the pathologist's report and the expert medical opinion, which of course is where I found the detail of these doses. And when he transferred to Kilmarnock prison, unfortunately, he was back on 500. The pathologist, in Scotland, the extent of post-mortem is controlled by the procurator-fiscal. The deputy procurator-fiscal was asked by the lady pathologist to allow specialist neuropathology in this case. And he said, no, dear, I don't think we need that. And she made a point of writing in her report that her request for specialist neuropathology had been denied. In the write-up, they said there was more methadone in this man's system than would be expected, given his dose of methadone in the prison. Except that when you read the medical examiner's report, they didn't know what they'd dosed him with because they hadn't recorded it. He'd had a visit from his wife and daughter, and of course there are security cameras in the visit hall, and they follow the prisoners back to cell. Those weren't called in evidence, because of course it was left open that somebody had passed him some extra methadone in visits. They could easily have secured the scene, secured the cameras, and shown that that was not the case. This man returned to his cell, had a grand mal seizure again, and died. And there were no, there were some recommendations meant. So, courtroom issues, anecdote versus empirical data. Throughout these written determinations, the sheriff would accept the view of the prison doctor, for instance, how many people were on high-risk assessment, suicide watch in any given week, whereas, of course, there are data in the prisons and in the prisons, in the reports of the chief inspectors of prisons. Not ever, never were those reports taken into account. Different, as I said, different family, each prisoner family typically would have a different lawyer advocate, whereas the Scottish Prison Service engaged always the same legal team that had amnesia about the previous cases it had dealt with the week before, the month before. And the sheriffs did not share experience, so that you had this heterogeneity of findings for essentially the same thing. So, recommendations to sheriffs that fatal accident inquiries should end within a year, and that 90% should end within a year, and 90% of written determinations should be written up within 90 days, so that 90% of fatal accident inquiries should report within 455 days. Inspector of Prisons detailed reports, certainly by the likes of Clive Fairweather, to be entered in evidence. Lawyers for prisoner families should apply my scrutiny rules to know which written determinations to look at for precedent. Parliamentary or other oversight is needed to ensure that recommendations are adopted system-wide, not just in individual prisons, but also in individual prisons, because Kilmarnock illustrated that was not the case. Fortunately, subsequent to this, there was a report into fatal accident inquiries in Scotland by the Lord Cullen. The paper arising from this was the only non-legal reference, and most of the recommendations here were taken up in the Lord Cullen's report. How are things in England and Wales? Well, of course, in England and Wales, unless Bernard can update me, we can't answer the question. Both because of late reporting of fact of death, but we could answer it from military inquests at the start of operations in Afghanistan, when 49% of military families waited more than 455 days for a verdict from a military inquest. Thank you.
Thank you very much, Sheila. It's nice to be reminded that we're not just talking about statistics and arguing, but it's actually about people's lives. And it would be good to bear in mind that statistics and probability can help the courts in administering justice beyond deciding on the sentence, but ensuring that lives aren't lost for financial reasons, particularly.
In England, I understand that the primary medical care is from local GPs. Does that happen in Scotland? And in fact, there have been great complaints because the GP gets a contract from a clinical commissioning group, but actually they often don't fulfil their remit. And I'm just wondering what the primary care is like in Scotland, because it sounds as though it's very poor.
At this time, the healthcare of Scottish prisoners was a responsibility of the Director for Healthcare for the Scottish Prison Service. And Scotland actually had a series of very good directors of healthcare, so that, for instance, hepatitis B immunisation for all prisoners was introduced in 1999 in Scotland, not until about 2006 or so in England. But not all of this, by any means, is poor care. Some maybe medical mishaps, sometimes missing a duodenal ulcer or something like that. But the tragedy of prisoner death is a tragedy for fellow prisoners, for prison officers, for everyone involved, as well as for the family of the prisoner, obviously, and the desperation of the prisoner who had actually died. Now, the health of Scottish prisoners is the responsibility of the National Health Service in Scotland, as it is in England and Wales. The change in England and Wales was expected to, and did, substantially improve matters. The jury is out, I think, in Scotland as to whether the change has actually improved matters.
Just one last question from me.
Sure.
There seems to be some indication maybe in what you've done that people drag their feet on the reports because they know something isn't working well, and they're taking. But why would that be the case for military inquests?
The same reason. Often the reason there were delays in military inquests is there was a board of inquiry, such as friendly fire deaths, or blue on blue, or green on blue, and so the fatal accident inquiry, or the English equivalent, would wait until the board of inquiry had concluded before the
So you feel pretty certain
inquest
that there's a correlation between lengthy inquiries and something wrong that happened?
In these I mean, this suggests so, and there are other, there is other thing that if something takes a long time, it is often giving the authorities time to have put things in place so they can say, well, we've dealt with all of those criticisms. But sadly, the story at Kilmarnock was such that the evidence was to the contrary, that they hadn't been dealt with.
Okay, well, thank you very much.